by sanction. So are we saying that if the laws are not written down or codified, there are no laws?
In positivist law, we believe that a law is law once it is enacted, backed up by sanctions. These are the key elements. When they lack these elements, positive law does not see them as law. Whereas it might be opinions of people, but then they are not binding laws to the positivist school of thoughts.
Okay, according to John Huston, the existence of law is not dependent on the efficacy or the wise of the law. Is this position not preventing the improvement upon law or reforms upon law?
The positivist law school, yes, says that written law is law and enacted law is law. But however, it does not change or disapprove the enactment or amendment of law. For example, the Nazi laws in Germany, which we all know caused the Holocaust and the gruesome murder of several Jewish people. That law was unjust. However, under positivist law, due to the fact that it was enacted and written down, we recognize it as law. But we also recognize that this law is unjust and is open to amendment. And so it is open to reformation, but however, it remains law as long as it exists until it is amended.
Yeah, also, God forbid that we tell you that positivist law does not support judicial activism and legal activism, whereas positive law provides laid down rules to amend and also to amend and correct laws. Once these laws are followed, if the efficacy of the law is gotten through due process. Thank you very much.
The last question, how do you address the issue of customary law that is not codified or written down as regard to codification of laws, like you said?
Under positivist law, once again, we recognize written laws and enacted laws as laws in the Nigerian legal system. Customary law is not seen as law, not recognized by the courts, and not recognized by law until it's subject to the principles, the repugnancy doctrine, the doctrine of public dictates, conscience, and morality. And as such, we can see that customary law is not positivist law, but it is subject to the superior law, which is that of the positivist.
No mountain to have for any man to climb, just like your favorite sign. Don't be shy of all the mistakes you made in life, we all fall off sometimes. My man don't need a man, but the child needs a father. Oh, please be wise. Check out the climate, if it rains, but don't stay till the sunrise. Sunrise. Sometimes you break your heart just to save your soul. With God, I trust my life till I may go.
Amarugede ekuhecheye.
Abiare.
my brother, you know how this country is. Things being very expensive. Just yesterday, I bought 1 cup of garri for 250 naira. Hey! But you never know what will happen.
My lord, I'm super excited. Finally, we are getting married. We are the day that I dreamed. Without you, my existence is fallacious. I still love you, my baby.
My fellow elders, join me. I see you enjoy yourself. Please, join me for obese wine. This is obese wine. I heard obese join me.
In the 4 kingdoms,
Bam!
his great grandfather was mighty.
Bam!
His father was the best.
Bam!
Bobby is doing good for us.
Guys, please. Please, join me. Thank you.
In the news today, the Nigerian Senate has passed the bill for the legalization of consanguineous marriage into law. This new law allows for brothers and sisters to be legally married. Now the news in details.
It's not possible. It's not possible.
Everywhere. What nonsense?
Anyway, let us continue drinking. Ichie. What is wrong? Uchenna.
What is happening?
Mazi.
What's going on?
Mazi, come and join us for wine.
What's going on now? My elders. How can a goat give birth in a barn with their elders at home?
This is always my problem with you. Why is it that every time you want to speak to the elders, you start with a problem? You are with your fellow elder. You the beans.
My elders, a wild dog has entered the community to define our land.
Maz,
What is that?
speak in clear terms.
What is it? Okonkwo is giving his daughter's hand marriage to his son, her brother.
Hey!
In this land,
It cannot happen.
In this
Elder, it cannot happen.
it cannot happen.
We must be there.
We must be there.
Yes.
Yes.
Let's go.
Hey.
Let's go. Let's go.
Let's go to that city. Let us go and see what is happening.
wife, you've made me the happiest man today. Thank you for accepting to be my wife. With you, our journey is endless, filled with love. My perfect world. I love you to the end.
Yes, baby. From the very first time you set your eyes on me, because I know you set your eyes on me, our love bloomed. Baby!
With the past conferred on me, I confer you both, Ogechi Williams Okafor and Ojuku Williams Okafor, as lawfully wedded husband and wife. You may now kiss.
Where has it ever been done? Your grandfather did not do it. Your father did not do it. You want to do it. Why? Why?
It will not happen. It will not. It will not happen. It can never happen. Hey, what's going on? Hey, what's happening? What? Shut your mouth. Who are these people?
These old men do not want my children to get married.
Why? And why is that? That is an abomination in this custom. Yes, we are the custodians of the tradition. Hey. We will uphold the tradition.
Shut your mouth. Shut your mouth. Don't you listen to the news? What news?
The bill has been passed on this issue.
What nonsense? What nonsense?
We are going
And it should not be confined by the injustice in the society. It should not be confined by the subjective morals imposed by the society. According to Kelsen, the validity of the law, of a norm, stands its adherence to a higher norm and not to moral judgment.
My love, our love is not in violation of any ground norm. The fundamental right, which is enshrined in our Constitution, protects our relationship, my love. My love, together we've created our ground norm. We've created a little world.
Our love is free. Our love is bound by the ground norms of the society. Our love is free and is bound by the ground norm of the society.
Thank you.
They don't know, they have no clue. I don't fall in love. I don't fall in love. So not this one, no not they enjoy. She not this one, no not they enjoy. I don't fall in love. I don't fall in love. So not this one, no not they enjoy. She not this one, no not they enjoy.
The Dean of the Faculty of Law, Professor Mojisola Eseni, members of staff, the panel of judges, good students of Lausanne, ladies and gentlemen, we are members of Group 4 and we are here to give an exposition of the pure theory. Now, unlike the other schools of thought, the pure theory is one school of thought you don't really get what it's about by just hearing the name. But gentlemen, it's actually very easy to understand when explained. Now, what is the pure theory? Now, out of all the schools of thought, only one person attempted a scientific definition of law, and that was Hans Kelsen. And for him, law should not be influenced by other extraneous factors like custom, politics, history, or anything at all. And in order to achieve a law not influenced by this thing, he propounded what he called the theory of norms. That is a system, a hierarchy of norms, in which the lower norms gain validity from the higher norms. And the highest norm in that system of norm is called the ground norms. Wait this. Now, there is a norm. You ought to give alms to the poor. You now check, where does it get its validity? Oh, the pastor said this. The pastor is not within the legal system. So, norm, petroleum companies ought to pay tax to the government. Where does it derive its validity? A higher norm, the Petroleum Industry Act. Where the Constitution, which gives National Assembly the power to make those laws. You see that within the hierarchy of norms, the payment of tax have been established. So it is a law. Now, gentlemen, I also know in the drama we just presented, when the elders wanted to destroy the marriage, what they should not have asked themselves was not their custom or their history. They should have asked themselves, have the National Assembly enacted the law? And yes, they did, which allowed it, and that is why they were on the wrong side of the law. And I also know that you would not leave the four walls of a family law class without being the popular assignment can cause found that they were not within the degree of prohibited degree of consanguinity and affinity. You concluded and they can marry. You did just the same thing Hans Kelsen would have done in that situation. I hope now you understand what we mean by the pure theory of law. And under our Constitution, the pure theory is established by Section 1, Sub 3 of the Constitution, which states that the Constitution is supreme and every other law inconsistent to the extent of that inconsistency shall be what? Null and void. It has also been established in case law, like the case of AG Federation against Ojukwu, where the defendant in that case was being prosecuted for conducting a public protest. And that case is very funny, because to conduct a public protest, you have to get authority from the government. Now, in what world would the government give you authority to protest? It is almost impossible. But the court looked at the moral side of it, and they had sympathy with the defendants. But they still concluded that because the law is enacted that you must get that authority, then they must get it. And they ruled in favor of the law in spite of the sympathy they had for the defendants. So that is what the pure theory is about. Now, my second speaker will be speaking on the comparative analysis of pure theory with other schools of thought. Thank you.
Thank you very much. Flowing from my lead speaker, you will agree with me that the pure theory has a lot of STEEZE and has a lot of composure. So very briefly, I'll look at comparative analysis of the pure theory with two other schools of thought. I would like to begin with the natural schools of jurisprudence. Well, natural law actually believes that there is a moral code built into the universe, just like physics predicts what makes a ball to roll, that natural law actually predicts what makes a valid law and what makes a law to be just. Well, I'll be looking at these two concepts on the perspective subjectivity and objectivity. Natural law is subjective in nature because it relies solely on morality and ethics, which varies from society to society, culture to culture, and even between. Now, you agree with me that what is said to be natural law in Nigeria will not be said to be natural law in India. Now, drawing the analogy back to Nigeria, you are going to believe, we quite know all right, that there are certain crimes which you can commit in the south freely, you enjoy, even in public, but you cannot try such in the north. Is it not so? So, what can we say of natural law? Now, looking at the adaptability and the rigidness of natural law, we would see that natural law is rigid due to its moral principles, unchanging moral principle. But pure theory is changing. Now the society is dynamic. It changes with time. We have new concepts, we have new issues emerging in a society like cybercrime, romance, fraud, blockchain, cryptocurrency. We have a lot of. Now, what will be the place of natural law in such a society? Pure theory is flexible and makes provision of natural law. Thank you very much.
Thank you, ladies and gentlemen. Standing on existing protocol, I believe my job here is very simple. We are trying to maintain STEEZE and composure. And I think that the pure theory of law has the STEEZiest of STEEZE. Why? Critics of this school have come out to say that the pure theory of law is not flexible. Can you imagine? Can you imagine? The pure theory of law, it is a law that is formed on a strict legal form. What it says is 1 + 1 is 2. So if you do this, this is the result, right? If you kill a man, you go to jail, right? But if a law is this law, definitely the law will listen to them. But that does not mean that the law states what ought to be. It always states what is. Pure theory of law, STEEZE Fulham. Thank you.
Thank you very much, Group 4. So my question goes like this. The pure theory of law posits that law only derives its Hans Kelsen admitted that the ground norm derives its own validity from efficacy. He described efficacy to mean the assent of the people, that is the common moral judgment of the people, thus falling back to natural law. So by falling back to natural law ideology.
Okay, thank you very much for giving me the opportunity to. The pure theory was written in German, and that's and the part of efficacy is actually a problem of translation. When Hans Kelsen was talking about the efficacy, he was not questioning the validity of in itself. Once it gets to the ground norm, then that law is totally valid. But now, on the question of whether that law is functional in the society or not, that was a sphere to ask the question: can bride price be less than maybe 30,000 naira? According to our laws, bride price is regulated and is way below that amount. Yes, it is valid. It can be less than that. But is it observed that? Is it efficacious? The problem will be, does the people practice it? Which is, even if the people do not practice it, it's not efficacious, but in fact, it is still valid and within the ground norm.
Pure theory of law oversimplifies the complex relationship. Pure theory of law oversimplifies the complex relationship between law and morality, ignoring how moral principles often inform legal decisions in Nigeria. Answer this in light of Section 214 to 231 of the Criminal Code, which provides for offenses against morality.
Okay, thank you very much for that question. And I feel you answered the question, but you did not know when. You said the pure theory ignores the influence. Yes, other things can influence the making of law. The pure theory is talking about the validity of law. How does a norm gain its validity? Not whether it is influenced by this or that, okay? So in as much as there are other things that influence the law when it talks about being influential, but when it is a question of the validity of the law, the pure theory is still complete in itself, in the sense that when you are asking yourself within those 214 to 218, it does not contain every possible morality against nature, does it? No. But the only valid ones which you can go to court for are those contained in those sections you mentioned. Reason not because moral law influences it, reason being because it is in that criminal code. And criminal code gains its own validity from the constitution, which is the ground norm of that society.
Okay, if you have attended Professor Moji's class, when we were speaking on law and morality, okay, I take it back. In Professor Moji Essaying's class, when we were discussing on law and morality, this is law, this is morality. There is a middle ground. But it doesn't mean that it is law, it is the morality that influences the law. There is a place that they meet. There are places that the law, we all know that this is against human reason. But it is not every moral thing that the law will now come. If not, it will be a wild goose chase. The law will chase everything, and the law does not have that time. Thank you.
Okay, like the first speaker said, very importantly, I think you're the one trying to misappropriate your question. The pure theory of law tends to emphasize okay, I take the van. Okay, thank you so very much, man. Pure theory of law particularly deals with the validity, not trying to address morality as the natural school does. Just like in the prominent case of Leonard McFaul versus UAC, where the court said you cannot put something on nothing and expect it to stand. It is just trying to let you know that there should be a hierarchy of norm, which is the ground norm and the basic norm. There should be a basics on which the law, which is applicable, should rest on. Just like it's also said in the case of AG Abia State and AG Federation, where it is said that the Constitution is the forces origo, not only of the jurisprudence, but also of the legal system. It is said to be the beginning and the end of every legal system, trying to differentiate between its validity away from morality. Thank you so very much.
You've asked them 3 questions.
Sorry, Ma, what did you say?
That's the 3rd question, right?
No, this is the 3rd question.
Okay, that's okay.
All right. I believe that your submission is from the proposition of Hans Kelsen, right? Good.
According to Hans Kelsen, a norm to derive validity must be derived from a higher norm, right? Now, what is the position of a coup d'etat that cuts abrupt the norm, the higher norm, and brings a revolutionary government? Is your submission that the laws made therefrom are not valid laws?
Okay, thank you very much. When a coup d'etat happens, like you said, the question of what happens has already been answered by the courts in the case of AG Federation against Lankami, where it was said that when a coup d'etat happens, that coup d'etat is no longer judged by the law that existed before it happened, but by the fact of its own sources. And if you really read Hans Kelsen and the original pure theory, he stated that national system exists differently from each other, so there may be a change in a national system, but at every time, the law is traceable to somewhere. So what has happened in that case is a change in a national system, and the laws they made are valid.
Members of the Year 5 class, please, if your group has presented and you have a mic that looks like the one that I am carrying, please get it to me. I went up stage and I gave it to one of the groups. This is what it looks like. I'm going to take it up so that you can see. If you have it with you in your bag, please get it to me. It's making it difficult for other groups to present.
Hold on. Don't say if you have it in your bag. If you have it in your possession. No. Saying in your bag is as if the person, if you have it around your environment. Let's have the microphone.
Please, if you have it in your possession, bring it forward. Thank you. Let's have it. Thank you.
Traditions and beliefs is what I know as law.
Pleaded guilty of murder, I hereby sentence you to death by hanging. The court shall rise.
What I know is law. What I do not know is not law. The vulgast.
I mean, everybody. On it. Hey.
What is this noise? Where does this noise emanate from? My head aches. What is this noise? Nsida! What is this noise? be quiet. Now, my children, gather round. I have a story for you. A tale as old as time, which spans through centuries. Listen carefully. And what I do not know is no law. My children, there was a man. He killed someone. And he was taken to the king's palace.
My elders. Ami, edi de me fio, e fit me mbom miem. Ye fruit to you don't want me. Ebo ya e kon onye. Ngotio. Bere ye ke go.
10 generations pass, and history repeats itself. A man is killed, and his killer is sent to court.
Having found guilty, I sentence you to death by hanging. God shall rise.
My name is Regina Jackson, and together we are members of the Historical School of Jurisprudence. There is a saying, a general aphorism at that anyone who wishes to foresee the future, such a person must be able to recount the past. Ladies and gentlemen, this is the premise that suggests that history is not only